Alright, this is video log 2. Illegal kidnapping of my girlfriend's daughter, blatant comments by CPS against the Constitution. I believe this is part 3. We're just going over some of the transcript here that I had, the conversation with DHS. I'm going to go over some more here and finish this up. So basically they're telling me that I am confirmed as a perpetrator and that I have a propensity to sexually molest children. Now at this time, the evidence they have against me is the allegations by my daughter. My daughter saying that I raped her on a specific date. That's all they have. No DNA evidence or any other proof. But I am guilty of this according to them. Alright, so here she tells me what my options are. There's a couple of options. I can turn it over to a family center service case, which means no court involvement. Work the voluntary service plan. So what she's telling me is, if I go to these courses that over 2 years will maybe treat me for my propensity to sexually molest children, that my girlfriend's daughter's not in danger. But if I don't do these classes, she's in danger. So basically she's saying, do these classes or we're going to take your kid. You're saying you're not going to work it, so at that time what I do is I would have to submit a report to the district attorney's office. She goes on to say, and I say, well, you know, what you're asking me to do is violate my Fifth Amendment rights and admit to a crime that I didn't commit in the first place. And, you know, that's going to destroy my case to start with, and I didn't do it. And she says, I understand that, and I'm sorry that I don't put your criminal case above my child welfare case. It's just that that's not how child welfare works. So they don't work with the law or under the law. I honestly don't care that much about your criminal case when it comes to I in the home. So I'm sorry. In other words, they don't care about the law, they don't care about what a jury says, they're just going to do what they want to do. Violate the Constitution and our rights. Then I get mad at her and I tell her, you know, one thing that irritates me is whenever you come into my home and you tell my girlfriend that he is a confirmed child molester. It's confirmed that he's done this. You know what I mean? That kind of stuff, it makes me mad. And she says, I understand that. And then I tell her, you know, that's kind of creeping into the area of slander. And then she looks at my girlfriend and says, he does have confirmed child welfare history, and I've made you aware of it every time that I've gone out there, and you've chose to stay in the home with him. And then she says, and I'm sorry if you feel that that is slanderous, but it's just not, because it's honest and it's the truth. And then I say it's not the truth. You come forward and you say he did this. He says, according to my case, it is the truth. And then I call her out because she tried to get my girlfriend to leave me long before this conversation. I call her out on it, saying that it's slanderous, attempting to get her to leave me and to not be with me, and try to take her away so she can't testify for me for my case, because she was there with me on the date that these supposedly happened, these allegations. And she says, no, it's to make her obvious to the facts, Mr. Dyer. And obviously we're not going to see eye to eye on this. I say obviously we're not. And then Amanda's asking if she does the course, will it keep them from taking her daughter? And they're saying no, he has to do it. It has to be both of you doing these courses. Here again they tell me that they need to come up with a treatment plan so that they can get out of my life. That's all that it's about, is to correct the condition. So the only reason I'm there is because they want to correct my condition to rape children. Amanda asks again, you know, if I did that program just for I's sake, or if Charles just does it for I's sake, are you going to go to court and try to take my children? And she says, you know what, honestly, I'm not going to answer that because I don't know, and I have no idea because of the criminal case. That's something you definitely want to speak with about your attorney. Amanda specifically asked, so if he did that, a program just for I's sake, can you go to court and say something like what his attorney's talking about? And what they're saying is, if I go to this, you know, they can go to court and say, well, he's taking these courses and it's voluntary and he admitted to being a child molester, and that's what they wanted to do. Okay, so that was pretty much the transcript of what they said. Once again, I want to point out that they said there's no imminent risk to the child. at all. No imminent risk. Alright, next thing we'll get into, alright, is the court hearing. So, I refused to sign these papers, and like they said, because I refused to do this 2-year course, and like they said, if I refused to cooperate, if I refused to admit to this crime, that they're going to take her child. So, it was a couple weeks, I think, later, we got a paper in the mail, and I think it was last few days in September, and it said that October 13th we had to go in front of a court and show our case, or the child would be taken from the home with emergency protective custody. Okay, no problem. I hit the law books. We got a public defender. Didn't know a whole lot about what was going on, but I hit the law books, brought up everything that we needed. Thank God for the internet, right? It's a whole new ball game out there these days. You don't have to have law libraries. So let me show you a little of what our evidence was against the state. Now this is something that I drew up. This may take a couple minutes. It's going to be kind of dry, but this is what I drew up for the attorney. All right. The purpose of this that I drew up for them was the purpose of this report is to assist in the defense of I and Amanda against the malicious legal attacks by the district attorney, because the district attorney was the one that was wanting to take her so that her mother would be out of state and not be available to be at my trial, because that helps him out, because then he gets a prosecution on me. Alright, here's what I wrote up. Evidence supporting our case according to Oklahoma state law. When dealing with a child depravity parental termination case, the Oklahoma court has acknowledged the due process of the law mandates that the state must produce clear and convincing evidence that the parents have violated the code set forth in Title 10 Alpha, Article 1, Chapter 4, Part 9, Section 1, Tac 4, Tac 904. And I have that in here as Exhibit 6. The court must look at 3 distinct interests in deciding to sever the parental bond. A. Parental claim to the child. B. The state's responsibility to protect underage citizens. And C. The child's rights to be free from harm, of abuse, and neglect. And this title I had in here at as example 19, exhibit 19 in this book. For the state to encroach into a family's life and disrupt their liberties is a serious violation of natural rights as well as Oklahoma state law. This is why clear and convincing evidence must be presented. Choices about family life is among associational rights that the Oklahoma court has ranked of basic importance in our society. Rights that are sheltered by the 14th Amendment against the state's unwarranted usurpation, disregard, or disrespect. It is fundamental in Oklahoma that the right of a parent to care, custody, companionship, and management of his or her child is a fundamental right protected by the federal and state constitutions. This is in quotations. That has long been the rule of this court that parents have by nature, as well as by law, the legal right to custody of their minor children. This right will always control the judgment of the courts, unless circumstances of great weight and importance connected with the necessary welfare of the child exist to overcome the strict legal right." Unquote. This is clearly shown in 2002 Oklahoma Civil Appeals Court 5-8, 4-6 Papa 3 Delta 1289, and I had that in here as example 2-9. Quote, "The interest of the child as well as parents' interest in the preservation of the family have a constitutional dimension that must be shielded with vigor and solitude." I had that in here as example 20. I've only got about a minute. I may have to put this on another video as well. "The state has completely failed to produce clear and convincing evidence that I has been deprived by the definitions set forth by the state of Oklahoma." And I put those in here as Exhibit 2-5. Also, that a deprived child is a child that can be removed from the home, stated in 2000 Oklahoma Civil Appeals 6-5. I have in here as 2-8 example. And subsequently has no right to terminate parental rights due to the violations of Title 10 Alpha, Article 1, Chapters 4, Part 9, Section 1 Tac 4 Tac 906 in here as Exhibit 6. Furthermore, refusal of compliance of a court mandate service plan cannot result in termination of parental rights unless the aforementioned violations can be proved. And I had those in here under examples 11 and 22. I'm going to stop there and I'll go over the evidence that supports our case there in just a second.